Hey, I'm Nancy Cavey. I'm a national ERISA and individual disability attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. The Florida bar says I have to say that this isn't legal advice. So I've said it, but nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the benefits you deserve. So off we go. Today, I'm going to be talking about medical care and your obligation to get medical care. What does that mean under the terms of your policy and what you need based on your medical care? Now, first, we're going to talk about your obligation to get treatment in an ERISA disability claim and a Social Security disability claim, because they tend to go hand in hand. Two, why you should tell the ERISA disability insurance carrier about the side effects of medication when you apply for your disability benefits. And lastly, I'm going to answer the question, should I tell my doctor that I'm having good days and bad days after my ERISA disability claim is accepted? All of this information is really crucial to getting and keeping your benefits. Let's take a break, though, before we get started.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at kvlaw.com today.
Welcome back to Winning Isn't Easy. Ready to get started? So let's talk about your obligation under the ERISA disability policy to get medical treatment. And we're going to contrast that with getting medical treatment as in a Social Security disability claim. Many ERISA disability insurance policies or plans require that you get reasonable and appropriate medical treatment as a condition to getting your disability benefits and as a condition to keeping your disability benefits. The policies or plans also will require that you apply for Social Security disability benefits. Why? Well, the disability carrier or plan wants the right to reduce your long-term disability benefits by the receipt of your Social Security benefits. Now, the question becomes, in my view, is the obligation to get medical treatment in an ERISA disability claim the same as it is in a Social Security disability claim? The Social Security Administration will rarely deny a Social Security claim on the basis that the applicant failed to follow prescribed treatment and is therefore not disabled. However, they do expect compliance with the medical instructions that are given to a patient, prescribed medical treatment. And the Social Security Administration says, hey, we expect that you're going to take the medication, or you're going to get the injections, or potentially you're going to get treatment. What will happen is that the Social Security Administration or a judge will make ultimately credibility decisions about your entitlement to benefits based in part on whether or not you've been compliant with the medical treatment that's being recommended. And what the Social Security Administration, claims examiners or the judges will say is, look, if you're not getting the medical treatment, if you're not complying with the medical treatment in terms of the nature of the treatment or the frequency of the treatment, you just are not as disabled as you would have me believe, because otherwise you would be getting the treatment, you would be following the prescribed treatment, and using that reasoning, the Social Security Administration will simply find that you are not believable or credible, and deny the claim. In fact, Social Security has regulations that will address this. It's Regulation 96-7P. And it sets forth in detail what you have to do to get your benefits and maintain your benefits. And this ruling says, look, that an applicant's statement about their symptoms and their functionality can be less credible if the level of frequency of treatment is inconsistent with the level of complaints, or if the medical reports or records show that the individual is not following the treatment as prescribed. And there are no good reasons for this failure. Now, this ruling will suggest that a judge or a Social Security claims adjudicator should not draw any inferences about an applicant's symptoms and functional effects without first considering any explanation that the applicant might provide or any other information in the case record that could explain this lack of care or this infrequent care or lack of compliance with care. Social Security rule, or rather Regulation 96.7p requires that the claims examiner or the judge inquire as to whether there are good reasons for this lack of treatment. So what are the acceptable reasons, and are these potentially applicable in the context of an ERISA case? The acceptable reasons recognized by Social Security for not getting medical treatment or be fully compliant are things like you could not afford the medical care. Now, the Social Security Administration will expect to see in your claims file that you have consulted with no-cost or low-cost medical providers. It might be the county health department or an organization like the Judeo-Christian Clinic. They want to see, they meaning Social Security, is going to want to see that you've made some effort to get the medical treatment. And they'll also want to understand, for example, why it is you may not have fully complied with treatment. So, for example, if there's a recommendation for surgery, there needs to be something in the medical records that address why it is you didn't have the surgery. It might be that you've had several surgeries before with less than stellar results, and you don't want to try the surgery again. It might be that you had a family or member or a friend who's had the surgery with poor results and had significant issues with disability. Or you may have known someone who had the surgery and ultimately committed suicide because of the lack of improvement. So if you're going to try to argue that you can't afford the care, you've got to demonstrate that there's an alternative method of care that you've attempted, and that alternatively, you're not accepting all of the medical care because of a well-founded fear of injury, disability, or death as a result of this proposed treatment. Now, the Social Security Administration and the judges will generally accept that reason if it's explained and well-founded. Not all judges or social claims examiners won't. But let's compare or contrast that with what the ERISA disability carrier or plan will do. And the answer is they're not going to take the same approach. Disability insurance claims are month to month, and therefore the disability carrier expects that you're going to be getting medical treatment with a frequency and level of care that's consistent with your claimed disability. So one of the things that you might argue is, look, I can try to control my pain or difficulties with structuring my daily activities in such a fashion to minimize my symptoms. Well, the disability carrier might say, if you can structure your daily activities, you can structure your work activities. Our other argument might be, look, my symptoms are not severe enough to prompt me to seek ongoing medical attention, or can be relieved with over-the-counter medication. Now, if you're not getting any treatment at all, you're violating your ERISA disability insurance policy or plan, and they can deny the claim on the basis of the lack of compliance with the terms of the policy. And no judge is going to overturn that. No federal judge is going to overturn a claims denial in an ERISA case if you've decided that you're not going to get treatment. Now, if you say, look, my symptoms can be relieved with over-the-counter prescription medication, that's not going to really fly in an ERISA disability claim, because they're going to say, well, if you can take over-the-counter prescription medication, your pain must not be bad, and it certainly isn't disabling, and it certainly isn't disabling to the extent to which you couldn't perform your own or any occupation. You might argue that you're not taking the prescription medication because of side effects, and those side effects are worse potentially than the symptoms. Now, that's not necessarily going to cut it in either a Social Security claim or in an ERISA disability claim. In the context of a Social Security claim, the Social Security Administration or the judge is going to want to see that you've gone to the doctor and complained about those side effects, and that the doctor has prescribed a different kinds of medication, which may or may not work, and which may or may not have caused other side effects. And the Social Security Administration or the judge is going to want to see that there's another attempt at medication trials. So you just walking into a Social Security hearing saying, I had these side effects and I didn't like them, so I stopped taking them, is not going to cut it. If it's not in the records, if there's not a trial of multiple medication attempts, including, other medication that has little or no side effects, it's just not going to work. And the same thing is going to be true in the context of the ERISA case. They want to see you've tried medications. If you've had side effects, they want to see multiple trials of medication and what impact that had on your side effects or your pain. You just can't waltz in a claim and say, I've got these side effects and that's why I stopped taking the medication. Not going to work. Now, how about the issue of the inability to get medical care because of the loss of insurance or you can't afford it? In the context of an ERISA case, it's too bad, so sad. The policy requires that you get medical treatment, and you may have been advised, on the other hand, that there isn't any further effective treatment that can be prescribed that would benefit them. Now, in that situation, what I'm telling my clients is that the ERISA disability carrier or plan is always of the opinion that some form of treatment that you could get would help you return to work, even if it may not benefit you on a long-term basis. That's kind of, I think that's a bit of a crappy reason to deny a claim. But what I do is if we are in a situation where the doctor is saying, look, there's not a lot more I can offer, I always try to get the disability carrier or the plan to address that and say, look, we understand, we'll accept that, but we expect that the person sees the doctor, this frequently. And by the way, we won't require attending physician statement forms every month. We'll just maybe do them every 6 months. That's something that I have been successful in negotiating in ERISA disability claims. Now, you might argue that the treatment that's being offered is contrary to the teaching and tenets of your particular religion. That will work potentially in a Social Security case, but not necessarily in an ERISA disability case. And what they're going to say in an ERISA case is, notwithstanding your religious beliefs or the tenets of your religion, you have an obligation to get medical treatment. And you need to get alternative medical treatment that does not violate your particular religious teachings or tenets. Now, you may have undergone surgery with unsuccessful results, and you're reluctant to have that surgery again. That, as I've explained, will work generally with explanation in a Social Security case, and that will generally work in an ERISA case. But both Social Security and the ERISA disability carrier plan is going to be saying, look, there are other conservative forms of treatment that you can get in forms of therapies, medications, or injections, and we expect that you are going to get that. Now, the treatment recommendation might be significant, and you're really reluctant to undergo that treatment. So it might be open heart surgery. It might be an organ transplant, those sorts of things that are sort of, if you will, beyond the normal, in quotes, form of treatment. Now, in the context of a Social Security case, again, if well documented in the file, that is generally acceptable. In the context of an ERISA disability case, if you're faced with a very risky surgery or a significant procedure and you're reluctant to undergo it, again, there are several things you have to do. One, you've got to document the nature of the surgery. Your doctor has to. The doctor has to explain in the medical records that they've explained to you the risks associated with this particular surgery, and that after a considered discussion that you have chosen not to undergo that surgery, and the doctor agrees, in view of your concerns, that you should not undergo this particular procedure or surgery. And then the doctor offers alternative care that is at best, conservative and palliative. Again, all of this is done with explanation. Now, Uh, Again, we need to talk about a particular surgery that may jeopardize the function of another part of your body. So let's say, for example, you have visual issues and you have problems with both eyes. Um, and the surgeon is recommending surgery on one eye, and you could potentially lose the vision in that one eye and have poor vision in just one eye, or potentially you could have a surgical procedure that could result in the loss of vision in one or both eyes. In that situation, again, it should be documented the degree of the visual impairment in the quote unquote good eye, the degree of impairment in the quote unquote bad eye, what impact having surgery on the bad eye, what are the risks associated with that, and then what impact could it have if that surgery wasn't successful on the remaining good eye, if you will. Again, well documented explanation as to why that particular surgery would be inappropriate. Now, in some situations, let's say you have a back and a knee condition. You've got a total knee, you've got a back that needs surgery on. You're reluctant to have that back surgery because you don't want to end up being paralyzed. You don't want to end up having the knee get worse. Or let's reverse it. You have had back surgery and you're having knee problems and you don't want to make it worse. Again, it's important that your medical records are addressing this particular problem and address why it is you wouldn't potentially wouldn't use any assistive devices. So you can see that the ERISA disability carrier plan can be very inflexible when it comes to the policy requirements that you get medical treatment. I know that was a long segment. We need to take a break and we'll be back with our other two features.